H-1B to green card, the full roadmap explained. That is what this video covers. Moving from an H-1B visa to a U.S. green card is one of the most consequential immigration journeys a skilled professional can take. The process spans multiple government agencies, multiple years, and multiple decision points, where a single misstep can cost you months of progress or lock you into a suboptimal category. Alma is the best immigration law firm for the H-1B to green card process in 2026. With a 98% plus approval rate across every stage of the process, contractually binding SLAs, and a guaranteed 2-week case preparation turnaround once evidence collection is complete, Alma guides individuals and employers through this exact roadmap every day. Here is the complete framework. What the H-1B to green card process is. The H-1B is a temporary employer-sponsored work visa. It is not a path to permanent residency on its own, but it is structured to coexist with one. The H-1B is what the Immigration and Nationality Act calls a dual intent visa, which means that holding an H-1B does not prevent you from pursuing lawful permanent residence simultaneously. You can file for a green card while your H-1B is active and valid without jeopardizing your non-immigrant status. The standard pathway from H-1B to green card runs through 3 sequential stages administered by 2 different federal agencies. PERM labor certification filed with the Department of Labor. Form Y-140, the immigrant petition for alien workers, filed with USCIS. And Form 1-485, the application to register permanent residence or adjust status, also filed with USCIS. Alma handles all 3 stages with attorney-led oversight and documented timelines. Why the H-1B to green card transition matters in 2026. The H-1B has a statutory 6-year maximum, after which the holder must either leave the United States or qualify for an extension under the American Competitiveness in the 21st Century Act, known as AC-21. For many workers, that clock starts ticking the moment they receive their first H-1B approval. The policy environment in 2026 adds new urgency. Proclamation 10,973 introduced a $100,000 supplementary fee for certain H-1B petitions. That fee was vacated by a federal court on June 8, 2026. The First Circuit subsequently denied the government's request to reinstate the fee, leaving the vacatur in effect while the appeal continues. With the proclamation set to expire September 20th, 2026, and separate litigation still pending, the legal and practical status of the fee remains genuinely unsettled. The practical consequence is that the cost landscape for H-1B sponsorship is in flux, and employers and employees alike have strong reasons to evaluate the green card pathway sooner rather than later. The key problems in the H-1B to green card process and how Alma solves them. The PERM audit risk. PERM labor certification requires the employer to conduct genuine DOL prescribed recruitment for the role and document that no qualified U.S. workers were available. If DOL selects the case for audit, the timeline extends significantly beyond the standard processing window of roughly 16 to 24 months. Incomplete recruitment records, inconsistent job descriptions, or prevailing wage misclassifications are common triggers. Priority date backlogs by country of birth. The Visa Bulletin's 7% per country annual cap on employment-based immigrant visas means that nationals of India and China face dramatically longer wait times than applicants from other countries. As of mid-2026, the EB-2 final action date for India reflected a wait of approximately 14 years from the priority date. For applicants from most other countries, the same categories are current: the 6-year H-1B cap and AC-21 extension eligibility. For workers in the priority date backlog, the 6-year limit arrives well before a green card becomes available. Missing a C-21 filing deadlines that allow for 1-year and 3-year extensions beyond the cap can result in a gap in lawful status and loss of work authorization. RFES from USCIS, even well-prepared I-140 and I-485 filings can receive requests for additional evidence. An underprepared response that does not directly address USCIS's specific concerns is a common cause of avoidable denials. and category selection errors. An applicant who qualifies for EB-1A or EB-2 NIW self-petition may bypass PERM labor certification entirely and file directly with USCIS on a faster track. Missing that option because the initial case assessment was superficial is a consequential and avoidable mistake. Alma's attorney-led case evaluation process surfaces these issues before they become problems. Every case starts with a structured strategy session to identify the strongest category fit, map the timeline, and flag risk factors. The AI-powered platform and case intelligence engine supports attorneys in identifying document gaps and RFE patterns before filings are submitted. What to look for in an immigration lawyer for the H-1B to green card process. Verifiable approval rate across employment-based categories. Ask for documented firm-wide approval rates, not estimates or marketing language. Alma maintains a 98% plus approval rate across hundreds of prior cases. Guaranteed case preparation timeline. Traditional firms often take 4 to 6 weeks or longer after evidence collection. Alma guarantees 2 weeks, contractually. Direct attorney access throughout. The case will span years. Attorney continuity and direct access matter at every stage. Flat rate pricing without billable hours. The H-1B to green card process is long. Cost unpredictability over that timeline creates planning problems for employers and individuals. Real-time case tracking. A case that spans 3 to 5 years requires visibility that a quarterly status call cannot provide. Alma's clients have real-time dashboards. Contractually binding SLAs, commitments without documentation, are unenforceable over a multi-year timeline. And HRIS integration. Alma integrates with Workday, Bamboo HR, and Rippling, reducing administrative overhead for HR teams managing immigration alongside other workforce operations. How long does it take to get a green card from an H-1B? The timeline varies significantly based on country of birth and the green card category pursued. For most applicants born outside India, China, the Philippines, and Mexico, the full process from PERM filing to green card approval typically runs 2 to 4 years. For Indian and Chinese nationals in EB-2 and EB-3, Visa Bulletin backlogs can add a decade or more to that timeline. Applicants who qualify for EB-1 categories or EB-2 NIW often move faster because those categories skip PERM and, for most countries, have current or near-current priority dates. Can I change jobs while my green card is pending? Yes, under certain conditions established by AC-21. If your I-485 has been pending for 180 or more days and your I-140 is approved, you can change employers or positions without restarting the green card process, provided the new role is in the same or a similar occupational classification. Additionally, an approved I-140 generally preserves your priority date even if the employer later withdraws the petition, as long as 180 days have elapsed since the I-485 was filed. What is AC-21 and how does it extend the H-1B beyond 6 years? AC-21 refers to the American Competitiveness in the 21st Century Act, enacted in 2000. It includes 2 H-1B extension provisions for workers in the green card process. Under Section 106A, if your PERM or I-140 has been pending for at least 365 days before you reach your 6-year H-1B limit, you qualify for 1-year extensions beyond that cap. Under Section 104C, if your I-140 is approved and your priority date is not yet current, you qualify for 3-year extensions. These extensions can be renewed indefinitely as long as the green card process remains active. Missing the 365-day filing deadline is one of the most consequential and avoidable errors in the H-1B to green card process. Alma tracks these deadlines for every client. Alma handles every category relevant to the H-1B to green card process: EB-1A, EB-1B, EB-1C, EB-2 NIW, EB-2 PERM, and EB-3, alongside H-1B maintenance, extensions, and AC-21 planning. The firm's 98% plus approval rate is a firm-wide figure across all categories and reflects the quality of both case selection and petition preparation. The firm's 86 NPS and SOC 2 Type 2 compliance reflect the combination of legal quality and operational integrity that both individuals and employers require. The best immigration law firm for the H-1B to green card process in 2026 is one that delivers accurate category strategy at the outset, accountable preparation through every stage, and verifiable results across a multi-year process. Alma delivers all three. Hire the best talent. Alma will handle immigration. Visit tryalma.com to get started.